But Marshall, kind of going on the line, what I want to ask you about, I mean, if you're watching this video, you can look up the statute and see the other factors. But the last two factors, I really want to get your opinion on this, is we have the domestic violence factor and the abduction factor, as well as there's also the abuse and neglect. There's also these presumptions out there that exist in domestic violence cases, and if there's an act of abduction, where there's a presumption it's not in the best interest of the child for the bad parent, for the parent who committed domestic violence under a separate statute, NRS 125C 230. How do you reconcile the best interest factors with those presumptions, and how should parties argue those?
I don't really think there's a substantial difference. I think it's just repeated in two different places. I've never seen them come into conflict. Short version is that if one parent has committed an act of domestic violence against the child's parent, or another person living with the child, there's a presumption that that person is not a good candidate for joint or primary physical custody. Now, does that mean that if there was a single incident, you're just out? And the answer is generally no. I've had an awful lot of judges over the years talk about isolated incidents, the crisis that precipitated the divorce or whatever. But there's some leeway. Some of it has to do with severity. Some of it has to do with frequency. Judges are more likely to ignore these factors on a one-off than if it was a continual pattern of behavior. And so the short version is that we don't want people who are inherently violent. The literature tends to confirm that people who are violent with their spouses or with pets or with other children are more likely to be violent with the child at issue in the case. And the same thing really applies for abduction. There's a statutory definition of abduction, but basically if you snatch and grab the kid and disappear under how it's defined, and it doesn't mean we went shopping without telling you. I mean, it means kidnap. And I don't want to get in too much into the weeds, but there is a difference. But if you've got a clear and convincing evidence that a parent has done either one of those things, then you've got a presumption against that parent as a joint or primary physical custodian. And unfortunately, sometimes we see situations where one parent was violent and the other parent cut and ran. And so the judges are trying to balance who was the good guy, who was the bad guy, and why did people do what they did. When they crafted the current version of our custodial statute, they tried to come up with language which indicated that if you were fleeing domestic violence, and I did a seminar on this, the materials are on our website. If you're fleeing domestic violence, the standard for kidnapping is much higher as a matter of proof to be held against you. The idea being that you're not required to just stand there and take it. If you have to run, and let the lawyers work out how that comes out after the fact.